Hello friends, in the YouTube channel Advocate Amit Kumar Gupta. Today we will discuss the case of RAVIKUMAR DHANDHANIA versus Income Tax Officer. This case has been decided by the Madras High Court and the matter has been reported in 447 ITR at page number 726. The matter has been decided on 8th April 2022. The whole issue involved in this case is that whether the interest can be levied on the assessee under section 234A, B and C. In this particular case, the assessee filed his return of income. After filing the return of income, assessee realized that some income has escaped to be incorporated into the return of the income. So the Assessee Suo moto revised the return of income and showed near about 3.25 lakh of 3.25 crore of income into its revised return. When this income was taken into his return, the interest liability came to near about 1.25 lakh and some tax was also there. Assessee paid the tax, and for interest, assessee filed an application for the waiver of the interest before the Commissioner of Income Tax under section 220 subsection 2A. The assessee plea was that I have suo moto included the additional income into the return of income and have paid the tax, so my interest should be deleted. But the principal Commissioner of Income Tax was not convinced with the assessee and did not accept the application of the assessee. The assessee filed the writ petition into the Madras High Court. The Madras High Court also didn't entertain the writ petition of the assessee. The assessee did not have any option, so the assessee paid the whole interest of near about 1.25 crore also. Now, after paying this interest, the assessee got one more demand notice of rupees 28 lakh, which was regarding the interest that was calculated by the department on that interest, because the assessee has deposited the interest very late. The reason was that because assessee was in the litigation, the assessee filed the application for waiver of interest before the CIT and then High Court. So this time was the reason for levy of interest on interest by the department. When the assessee received this 28 lakh demand notice, the assessee went again to the Principal Commissioner of Income Tax for this waiver. Again his application was rejected. The main plea of the assessee was again that I have paid all the interest and all my taxes, so my application should be accepted. When this application was again rejected by Principal CIT, the assessee went to the High Court, again filing the writ petition, and again the writ petition of the assessee was dismissed. The High Court said that your main ground for the application was that you have paid the interest and taxes, but the requirement of section 220 subsection 2 is something different. You have to show in that application that you have genuine hardship while filing the revised return. You have genuine hardship for the cause the interest has been levied for you. The assessee has to show that the circumstances was beyond the assessee's control, that assessee has not filed the correct return of income. The assessee has to show that the circumstances was beyond his control. And third point was that the assessee has to show that the assessee has cooperated in the assessment proceedings or the recovery proceedings. Only when these three grounds are there, the application for waiver of interest can be taken care of by the Principal CIT, and that is also his or her discretion. But the basis on the basis of which the assessee was fighting his application for waiver of interest was not correct. So Madras High Court again dismissed the writ petition of the assessee and directed the assessee to pay the interest on interest. When section 156 notice, which is the notice for demand, was issued to the assessee, it was clearly mentioned in that notice that if you will not pay the tax and interest on time, then an interest of rupees 1.5% will be levied on you. So the department has well communicated to the assessee, and the assessee application cannot be accepted in these circumstances. So friends, this case is very important. The intention of the assessee was very good. The assessee has suo moto come to the department and revised the return and showed additional income of 3.25 crore, has paid the interest of 1.25 crore. Even then his application was not accepted. So as per my view, the department should be very sympathetic to the assessee in these type of cases and should not be so harsh, because these type of cases will also demoralize the other assessees to come forward suo moto and pay the taxes. With due respect to the Madras High Court, in this case it was decided that the department can levy interest on interest also, because the law is like that. Once again, I am repeating the name of the case. The name of the case is RAVIKUMAR DHANDHANIA versus Income Tax Officer. Thank you, friends.